Good afternoon.
All right,
I'd like to reserve 3 minutes for rebuttal.
all right.
All right.
Give us your name, please.
May it please the court, my name is Elisa Tate. I'm from the Memphis Bar, and I represent the appellant Antonio Weston, the father of A.W., a 6-year-old child who tragically drowned at a birthday party in Memphis. This appeal is not about the merits of whether negligence occurred at the hotel pool, but we are here instead about whether Antonio's family was denied their day in court because the trial court dismissed this action on statute of limitations grounds, despite Tennessee law clearly supporting the First Amendment complaint properly relates back to the original filing under Rule 15.03. This case should...
How much time expired between the original filing and the amended complaint?
I've got a timeline here. The original filing was January 25th, 2023, and the appellees filed their motion to dismiss May 22nd, 2023. On September 18th, 2023, the appellants served discovery to identify the proper defendants, and on December 8th, 2023, we were granted a motion to compel the defendants to provide ownership information, and then that motion to amend was filed on March 21st, 2024. So there were back and forth discovery efforts, and we just did not know who owned it.
Well, and that brings me to my next question. What efforts, what did you do to try to figure out who owned the property to start with before you filed suit originally?
We did our due diligence, we thought, at the beginning with researching as to who the owners were. The names were very close, and that we could not for sure ascertain, and that's why we brought the action as XYZ Corporation.
Okay, and you filed that discovery motion to ascertain the ownership of the property sometime after the original complaint was filed.
That's correct.
Okay, and how long after that was that?
We filed, the original discovery was served on the defendants September 18th, 2023, and then we had a motion to compel that was granted on December 8th, 2023.
Okay, so from January to September, that's some months.
That's months.
And I'm not following how then this relates back. Tell me in the days how this relates back under 120-day provision.
Well, we had not been able to get that information. Now, I can't speak to what correspondence or what discussions were had from the plaintiff's side to the defendant's side, but we did file those discovery efforts. After we got their motion to dismiss, we did come back to ask for discovery to find out.
What duty is it of one defendant to tell you who you should have served?
Well, it is, I will concede it's not their duty, but they were on notice. These entities, these entities, we contend, were related, and they were represented by the same lawyer, so they knew all the time that these actions were pending. They had noticed that this action was going on.
What proof can I find, or where in the record can I find that they knew that?
Your Honor, I do not have definitively that they knew, but they were represented by the same attorneys. Their entities were related, and we believe it is our assertion that they knew that this particular action was going.
So are you saying it's the responsibility of a lawyer who represents one defendant to, if he thinks maybe it should have been another defendant that, or another party that he also represents, he should call them up and say, hey, this should be you?
I'm not saying that it's that, but I am saying that if these parties are related, you've got notice then.
Okay, well, where in the record can I find that they are related?
Again, I cannot say that.
Go ahead.
All right.
Just a clarification question. Are you saying that it's not in the record to your knowledge, or are you just saying you don't know where in the record that it is?
Today, I cannot say where in the record it is.
But you believe it is in the
I
record?
believe it is in the record, but I cannot today say that
Okay.
exactly where it is. Now, Tennessee Rules of Civil Procedure 15.03 states that an amendment relates back when it arises from the same conduct, transaction, or occurrence set forth in the original complaint, and the party to be brought in by amendment had notice of the institution of the action within the statutory period, such that it will not be prejudiced in defending the case. The rule also provides that relation back applies when, but for a mistake concerning the identity of the proper party, the action would have been brought against that party. And that's exactly what we contend we have here. This court and the Tennessee Supreme Court have consistently recognized that relation back is designed to prevent injustice. In Floyd v. Rentra, 675 Southwest 2nd, 165, Tennessee, 1984, the Supreme Court held that amendments correcting the identity of a defendant relate back when the defendant had timely notice of the action and knew it was the intended target. The court emphasized that relation back prevents dismissal where a mistaken name in the party was the only barrier to reaching the merits. Similarly, in Bennett v. Town and Country Ford, 816 Southwest 2nd, 52, Tennessee Court of Appeals, 1991, the Court of Appeals recognized Rule 1503 applies where the wrong entity was named and the correct entity had notice of the action. The court distinguished between impermissibly adding a wholly new party and correcting a misnomer or mistake in identity. Here, the First amended complaint makes no new allegations whatsoever. It repeated word for word the same negligence claims from the original complaint. The only change was correcting the defendant's names once ownership information became available. And in Grantham v. Jackson, Madison County General Hospital District, 954 Southwest 2nd, 36, Tennessee, 1997, the Supreme Court explained that the relation back rule is satisfied when claims in the amended pleading arise from the same occurrence as the original pleading. That condition is plainly satisfied here. The drowning incident and the negligence allegations have never changed. The trial court erred in treating this as an addition of a new defendant rather than correction of a misnomer. From the beginning, Mr. Weston included XYZ corporations and John Doe's in the original complaint because he did not know the true identity of Doubletree's owners. Through discovery and only after a motion to compel, the proper names, GP Memphis LP and GP Memphis GP LLC, were revealed. This was a classic case of mistaken identity and not an attempt to add a new defendant.
Well, didn't I read in the briefs that the trial court was able to look at the public records in this matter and see who the owner of this property was?
I did not see that in the record, but I do know that we...
That's in the defendant's brief.
Okay.
Did you review the defendant's
I
brief?
did review the defendant's brief.
Okay.
I did review that.
There's a lot in the defendant's brief about
Yes, Your
that. I
Honor.
think it even quotes what the trial court said.
Yes, Your Honor. Yes, Your Honor.
But you aren't familiar with that?
I'm familiar with it, but I did not, that particular portion, I do not have that before me right now. I did read the defendant's brief. Yes, Your Honor.
Let me ask you, how do you satisfy that the parties brought in by the amendment had notice or should have known? How did you satisfy that? What's the evidentiary proof to satisfy those requirements for relating back?
Well, as I state, it's our position that those were related companies that owned that hotel, and as such, they received notice when these lawsuits were filed.
How?
They were entities of, they were related entities, and that's our position on that.
Is there do you have any proof that they were related entities other than the fact that they've got similar names and that they are represented by the same attorney?
Today, I do not.
And so once you uncovered that, did you take any discovery at all to establish those portions of the rule that's required for the relation back? I know you're saying you think they're related entities and they're represented by the same council. I mean, how is that established in the record?
We did have discovery regarding who the true owners of the property were after, in September of 2023.
Did that discovery include any inquiry into or produce any answers as to the notice purportedly held by those people? I understand you're saying you were looking for the names, and I'm understanding that your discovery was as to the names of entities. But did your discovery in any way extend into notice upon the other entities?
Your Honor, that I cannot say. On that, I cannot say that it went that far.
Okay.
I cannot say that it went that far. I do know that it went as to who was the true owner, but as to that relationship, that I cannot say. And so, excuse me. Again, we feel that the trial court erred in treating this as the addition of a new defendant. Through discovery, and only after a motion to compel, that is when we found out who the entities were. And again, we look to the Supreme Court's reasoning in Floyd v. Rentrop, where there the Supreme Court permitted relation back even though the correct defendant was not named until after the statute of limitations period, because the defendant knew it was the intended party. The same reasoning we feel applies here. And I see almost all my time is gone, but we believe this is a fairness issue, and Rule 15.03 was intended to avoid injustice, and we would respectfully ask that the court would allow us to proceed on our claim. Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Jeff Nickerson, and I am the counsel of record for the appellees in this matter, GP Memphis LP and GP Memphis GP LLC. The appellees were not the original defendants to this lawsuit. Park Hotels and Resorts and Doubletree Hotel Systems were. Those were the original defendants that were sued by Mr. Weston and his counsel. And in suing them, neither of them in the complaint were listed as being the owner or the operator or even the franchisor of the property at issue, which is the Sanderlin Hotel in Memphis, Tennessee. However, paragraph 4, which the court can find on page 2 of the record, expressly states that they sued unknown XYZ corporations and specifically stated that those unknown corporations were the owners, operators, or franchisors of the hotel. Despite this, and as the timeline was laid out by my opposing counsel up here, very little was done to actually determine who the record owner of the property was. In fact, the record shows no such efforts that were performed before the initial complaint was filed. And what it does show after that is a bit of a tortured path that was related to a motion to dismiss for Park Hotels and Doubletree Hotel Systems on lack of personal jurisdiction. The discovery that we were discussing earlier with my colleague, that discovery was aimed at personal jurisdiction issues. It was not aimed at determining whether or not there was a question of relation back, because that question had not been raised at that time. Relation back came up in July of 2024 after an amended complaint was filed in May of 2024 to name GP Memphis and GP Memphis GP, which I'm just for the sake of not tying up my tongue, I'm going to call the appellees or the GPs. They were added only at that point in time, more than a year after the original complaint was filed in January of 2023. The claim was made in the argument before you that there's a commonality of interest between Park Hotels DoubleTree Hotel Systems, and the Applees. The record reflects no such commonality, and our position is there is none, especially considering it is the plaintiff's burden to establish the relation back elements. Relation back started as an equitable doctrine in common law. It was designed to ameliorate the possibility of a technical defect that would prevent a complaint from moving forward. As Tennessee jurisprudence described that, the question that would be raised is whether or not a new complaint merely cured a defect in the original proceedings, or if it was in substance the commencement of a new litigation. That rule was later codified as Rule 1503, which was here about today, and through various amendments, it became the form that it is today, which includes the 120-day period that Judge Smith was discussing about after the commencement period. As Doyle against Frost noted, this neither limits nor extends the statute of limitations period. What it does do is it opens a window of opportunity for a plaintiff to correct a defect, provided they can have the right combination showing notice and knowledge, subsections 1 and subsections 2 of Rule 15.03. In this case, neither of those were shown when this motion was made. The plaintiff's brief, if you read it, really doesn't address notice at all here today. And while there's a contention of notice, you are not pointed to anything in the record relating to that. Specifically as to the knowledge requirement, which is that the new litigant knew or should have known that but for a mistake or misnomer that they would have been brought into the lawsuit, there's likewise no such proof here. As I pointed out, there is no commonality between Park Hotels, DoubleTree Hotel Systems, and the GP entities. If the court looks at the motion to dismiss for lack of personal jurisdiction, there was a declaration from James Smith explaining the nature of DoubleTree Hotel Systems and Park Hotels, and how both of those were tied to Hilton Worldwide Holdings Incorporated. Park Hotels being a direct spinoff of that, becoming a real estate investment trust. DoubleTree Hotel Systems becoming an indirect, wholly owned subsidiary of that at the time this lawsuit was filed wasn't even in existence anymore. It had been closed down. GP Memphis and GP Memphis GP don't share registered agents with Park Hotels and DoubleTree Hotel Systems. The registered agents for the original defendants were with CSC in Nashville. The registered agent for GP Memphis is in Memphis. The registered agent for GP Memphis GP is in Wilmington, Delaware. There's been no showing of any evidence where notice was sent to GP Memphis or GP Memphis GP of the original lawsuit. As the Court of Appeals stated in the 2007 Jones case, simply amending the complaint to name the actual owner without evidence in the record suggesting an attempt to actually serve process on that entity's agents does not impart actual or constructive notice to the proper defendant. Further, the purpose of Rule 15.03 is not to allow someone to add a new defendant. It is, as was stated in the Grantham case by the Tennessee Supreme Court in 1997, designed to correct mislabeling of a party. We don't have mislabeling here. We have, unfortunately, a tactical decision that was made by the plaintiff to sue Park Hotels and DoubleTree Hotel Systems. And in doing so, as I pointed out, and again, you can look on page 2 of the record, paragraph 4 of the original complaint says the unknown XYZ corporations are the owners or operators of the property. In other words, at the time this lawsuit was filed, the plaintiff knew they had not identified either the owner or the operator, and instead chose to sue different entities that had no ties to the property whatsoever, and later filed a motion to dismiss because of a lack of personal jurisdiction because of that.
And DoubleTree and Park were dismissed.
Yes.
Okay. How did that come about?
That came about after the amended complaint was filed.
Did they non-suit them?
An order was entered dismissing him with prejudice, and that was entered about 8 days after the amended complaint was filed.
Okay. Was that done by consent?
I believe it was done by consent, yes, Your Honor. So they were dismissed. They are not appellees in this matter, and they are no longer involved in the matter. However, as to GP Memphis and GP Memphis LP, Judge Smith, you actually hit on this, and the court can go to volume 6 of the record and look at pages 35 and 36. And we cited this in our brief. The motion to compel hearing that opposing counsel referenced in December 8th of 2023, Judge Chumney was on the bench, and during this approximately 2-hour hearing that we had, getting down into the weeds over the personal jurisdiction discovery issues, she made a couple comments. The first was on page 16 and page 17. also in volume 6. And the first was she raised the point of whether or not anybody had looked online to see if they could identify who the record owner of the property was. Listed a name, Cooper Industries, was what she raised. And on pages 35 and 36, the record shows something that is honestly quite telling and informative in this situation. Judge Chumney does not say what she was looking at specifically, but she got online and she began to pull in instrument numbers from recorded instruments that one can get from the Shelby County Register of Deeds, and began reading off those instrument numbers. And the very first number that she read off, and we cited this in our brief, was instrument 22010396. That instrument was recorded 3 days before AW tragically drowned in the hotel pool. It was recorded on January 26, 2022. And it was assignment of rents related to a deed of trust, and identified GP Memphis LP as the grantor. And if one looks at that document, it explains the history of ownership going back into the 1980s, which began with Garden Plaza Hotel Company 3, and then in 1993, that was changed to GP Memphis LP, which has remained the record owner of this property ever since. GP Memphis GP signed that document in January 26, 2022 as the general partner of GP Memphis. So as to identifying the owner, our contention is that the work was simply not put in. There is an obligation for the plaintiff to investigate and to make proper determinations as to who should be sued. The plaintiff is, after all, the master of the complaint. My clients don't pick to be sued. They don't pick where to be sued. They certainly don't pick the causes of action or the facts that are alleged, but the plaintiff does. And as we noted in our brief, one of the problems that plaintiffs can run into is if they wait too long to file their lawsuit, they can run up against the wall that we're running up against today, which is Rule 15.03. But again, the plaintiff can avail themselves to the relief that allows to avoid the strictures of the statute of limitations, but they have to show the notice and the knowledge.
Was there anything done discovery-wise, interrogatories, depositions, anything of your clients to ask whether they had knowledge?
My clients being GP Memphis GP and GP Memphis? No, Your Honor, this was taken on a Rule 12 motion. And I will note that the record does have information that was put in by the plaintiffs in support of that, and we believe that they had every opportunity to put into the record what they wanted to, like they did, and there was reference to prior communications with me, which they did put in, and those are letters and emails going back into 2022, where correspondence was sent to the Doubletree Hotel, not a company name, just the hotel at the address, and I responded saying, I do represent the hotel. And when asked that by Judge Chumney, and that's in volume 4 of the record, I think pages 18 and 19, if you want to double check me, I did acknowledge prior representation, previously being hired earlier on was my phrase for GP Memphis, but not for GP Memphis GP. But again, to connote notice under that set of circumstances, it doesn't quite get you there because those communications were pre-suit. A pre-suit communication doesn't cut it. The Hensley case, which we cited in our brief, talks about somebody reaching out to a hotel after a trip and fall incident and saying on through the online portal, complaining of this incident and saying, I got hurt, we're probably going to sue you over this. And they tried to rely on that when they didn't sue the proper entity of the hotel later on, and the Court of Appeals said, no, that doesn't cut it, that's pre-suit. Notice of a potential incident isn't notice of a lawsuit. So what we haven't done that is here, and by the way, it's also in the record because I was asked this, I stated, I'm not the registered agent or an agent of service of process for either of the appellees here. I'm not going to sit here and say I wasn't representing GP Memphis earlier than when I appeared for them, which was in July of 2024. But that's not enough to get over the hump, and that was what Judge Chumney stated. And you can see it, I note this, like the order that she entered is in the record. It talks about an Exhibit A, which for some reason is not fully attached, but the court can find that in Volume 5. And you'll see that Judge Chumney put handwritten notes on the transcript. She asked us to provide that to her. And she put handwritten notes on that. And if we need to update that so you have a unitary copy, we're happy to supplement the record on that. But Judge Chumney stated, and it should be on page 13 in that Volume 5, she just simply said, look, the plaintiff, they didn't carry the burden. There's insufficient information to show notice. It's not clear on some of these questions. Under the circumstances, the motion was filed, and the plaintiff had every opportunity to put the information in. It's their burden to cover. To your point earlier, it's not our obligation to do some of the work. I'm not saying that to be unkind, but again, this is publicly available information. Judge Chumney found this one within a matter of moments, sitting at her desk with an open web browser. The Shelby County Register of Deeds is free to access. You don't need a subpoena to reach it. These are easily available public records. So, when we sit here and we look at this, we just don't see it. Again, this isn't a mislabeling issue. This was a deliberate tactical choice to sue two Hilton Worldwide entities that had nothing to do with the property, that didn't own it, that did not control it, and then only later on, after a protracted period of time where the information had been publicly available for years, were the appellees added. And under that set of circumstances, that's not a mislabeling. It's just simply a tactical decision to sue, and then you're trying to reform your lawsuit around who, at least one of who, should have been the original defendant. But again, as I said, that's not the choice the defendant makes, that's the choice the plaintiff makes. So under the circumstances, with that burden, Judge Chumney found that there was no relation back. And we agree with her. We think she reached the correct conclusion in this matter. And we don't say that lightly under the circumstances, but again, the record says what the record says on this. And the whole point of this is not to allow someone a do-over. The statute of limitations has to have some teeth. Relation back bridges that gap, but it still leaves the teeth in place. So under the circumstances, I'm happy to answer any questions you have. I've got about a minute left, but I think I've said all that I plan to say. We believe the decision was correct. We'd ask that this court affirm it in all respects.
All right, thank you for your argument.
Thank you for your time.
I would just like to say that I still would say that we would want our clients to have their day in court, and we still believe that relation back applies respectfully. Thank you.
Thank you. All right, we'll take your matter under advisement and endeavor to give you an opinion as soon as we can. Thank you. Sanji, that's the last thing we have today? All right. Please.